Hello, my name is Edward Batista, and this is my podcast. It is a podcast about things involving the law, the legal field, things you should know about, things you might not know about but would like to, and like that. So today's topic has to do with the life cycle of a lawsuit. Typically it takes about a year, and it starts off usually with the sides trying to work it out. A lot of times, though, unfortunately, that does not work. So then the plaintiff in the action, the person bringing the case, has to file in court a complaint. A complaint is the document used that starts the case. So a complaint's job is to list what are called causes of action and support those causes of action with the elements that are needed to make up that cause of action. So using food as an analogy, you want to set forth your menu items, those are the causes of action, and then you want to specify what facts make up your ingredients or your elements. And that's really all it's about. The overarching idea with a complaint is to make sure you give the other side adequate notice of what it is that they face at trial. Because it would be unfair to, at the end during trial, hold them to account for something that they couldn't have reasonably known about or reasonably known that was even on the table from your complaints. You want to put them on notice about that. You then personally serve it with the summons that you got when you filed the complaint with the court, and then they have 30 days to either answer or do a demurrer. With regard to the answer, they typically just deny all the specific factual allegations you made, and then they assert what are called affirmative defenses. And an affirmative defense is basically saying, hey plaintiff, even if everything you said is true, you still can't win because of blank. A good example would be statute of limitations. Hey plaintiff, everything you said might be true, but you brought your case too late and it's barred by the statute of limitations, you lose. Now, a demurrer is a motion that you can do with your answer or in lieu of an answer. And the idea there is you're saying, hey judge, this person has alleged that I did something that isn't even a thing against the law. They have not stated a claim on which relief can be granted. So if I sued somebody for waiting at a bus stop and I ask for $100,000, they're going to fire back a demurrer saying, Your Honor, they have not stated a claim on which relief can be granted because standing at a bus stop, there's nothing wrong with that. It's perfectly allowed. Once the complaint, answer, and demurrer phase, the initial pleading phase, is out of the way, then you get into the discovery phase that lasts anywhere from 6 to 8 months, and it's where you basically get all the information about the case, where you discover certain things, you exchange information with the other side. The written discovery are form interrogatories. They're called that because they're literally on a form. You just check the boxes that you want to ask. There are special interrogatories in which you draft your own questions to the other side. There are requests for production of documents in which you're asking for certain documents that you spell out. And there are requests for admissions in which you are trying to get them to admit or deny certain facts. And typically requests for admissions are to eliminate all the little minor issues that there's really no contest about. So you get them to admit it, and then it's kind of dispensed with. It's not going to be a big issue at trial because both sides agree. But of course, if they deny it, then it's a contested issue for trial. The other aspect of discovery would be depositions. You can get depositions of the other side. You can get depositions of witnesses and like that. Subpoenas are useful because you can get records and documents from certain entities that you might need. If it's a medical malpractice, you want to subpoena medical records. If it's a finance case, you might want to subpoena bank records. During that middle discovery phase, you can end the case right there instead of having to go all the way to trial through certain motions. They're called motions for summary judgment or motion for judgment on the pleading. The idea being, hey, Your Honor, we have all the facts we need early. What do you know about that? So we want the court to give us the relief that we want. A good example of how that might work would be if, let's just say, one of the key issues in your complaint is that they owned a white car. And you ask them in discovery, hey, did you own that white car? And they say yes. Well, they just proved your case, and there's really nothing left to do, so there's no need for a trial because it's already been conclusively proven that that one fact that you need is established by them out of their own mouths. Now, cases aren't usually that linear or simple. Even if you manage to knock one issue out of the park and get them to admit it, there's usually other issues, and usually it's never quite that clear. So those motions are rarely granted, but they do happen. So that's something you want to make sure you are on the lookout for during the discovery process to make sure that you don't already have all the information you need to win without having to go to trial. However, if the case survives, then you're in trial mode, and the idea at trial is simply to mentally have a list of all the things you need to prove. So you've got your causes of action, again, using food as an analogy, those would be the menu items, and then you've got the elements or the ingredients that make up that menu item. And you are simply matching facts and evidence that you have learned about or obtained through discovery to each one of those things, so that if you do your job, you have all the facts you need, you have all the evidence you need, documents, witness testimony, etc., and you just go down the list at trial, proving all those elements, and then at closing arguments, you give the judge the big picture that you've managed to complete proving all the things you said you were going to prove, and that's why you should win. Now, of course, the other side is looking to disprove those items, and that's really what trial is all about. The presentation of evidence to either make your case by showing you have all the elements you need, or by showing the other side doesn't have the elements they need, and that's why they should lose. So that's the life cycle of a case. It takes about a year. The meat of it is in the middle through the discovery phase. And I find that often knowing about the life cycle of a case makes a person who's involved in a lawsuit a lot more relaxed, because they know kind of when to worry, when not to worry. So many times after the initial pleading, people are calling every day, what's going on, and there's nothing going on, because the discovery middle section is a very dry, uneventful, often, phase of the case. So the beginning is usually dramatic with the answer and the demurrer that might come, and then the end, of course, trial is dramatic. In the middle, it can get pretty slow. So that's basically the life cycle of a case. If you have any other questions, check out my website, ebblawfirm.com or edwardbatista.com. Thank you so much for listening.